chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. In relation to the pretrial chamber's reliance on the notion of a network of supporters, the appeals chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The appeals chamber has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact. Regarding the arguments on the assessment of evidence, and in particular, the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risks existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines, and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable.
To demonstrate how the fact that the pretrial chamber accorded weight
In the
to
same
statement
vein,
from Mr. Duterte
the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)(b), subparagraph 3 of the statute was unreasonable.
that these factors are relevant
Moreover,
considerations
with regard
in
to the
assessing the
defense's
risk
contention that the pretrial chamber selectively
Article
cited facts and ignored others in the same items of evidence, the appeals chamber considers
of the statute.
that the defense has failed to
As
demonstrate
these are
how the
factors
fact
may
that the
increase
pretrial
an
chamber
incentive
accorded weight to the statement from Mr. Duterte that
for a
it
person
cited
to abscond.
should result in the pretrial chambers ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of
At the
conviction,
specific allegations against Mr.
it is
Duterte,
recalled that the appeals
follows
chamber has
the
consistently
defense
held
has failed
that these
to
factors
demonstrate
are relevant considerations in assessing the risk
regarding the
under
question
Article
of whether the pretrial
58(1)(b),
chamber erred
subparagraph
in
1
by
of the
failing to
statute,
give appropriate
as
weight
these
to
are
relevant
factors
facts,
that may increase an
specifically
incentive
Mr.
of a
Duterte's
person to
health
abscond.
condition and its mitigating
In the present instance,
effect on
the
risk
gravity of the
factors
alleged crimes
set
and the
out in
possibility
Article
of a lengthy sentence
58(1)(b) of
was
the
but
statute
one of the factors the pretrial chamber
argued
took
by
into
the
account
defense.
in its assessment of risks under Article
appeals chamber
58(1)(b), subparagraph
that
1
there is no
and 2
provision
of the
in
statute.
court's legal
And it looked at the
text
specific allegations
that
against Mr. Duterte.
specifically provides
It follows that the defense has
the
failed
entering
to
or
demonstrate
conditional
an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health
to grant
condition
interim release
and its mitigating effect
conditions.
on the risk factors set out in
The
Article
appeals chamber
58(1)(b) of the statute as argued
such
by the defense.
determination is
The
necessarily
appeals chamber recalls that there is no provision in the court's legal
case-specific,
texts that specifically
contrary
provides
to the
for the interim or
defense's
conditional
assertion
release
no
of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained
noted
person
the
may have an
reports
effect
placed
on the
before
risks under Article
and considered
58(1)(b)
that they
of
were
the statute,
unable
and
to
may
affect its
be a reason
finding
for a
on
pretrial
risks
chamber
under
to grant interim release
Article
with
58(1)(b)
conditions.
of the statute.
The appeals chamber considers
defense
that
has failed
such
to
a
show
determination is
That the
necessarily
pretrial chamber
case-specific.
chamber's approach was
Contrary
unreasonable.
to the defense's assertion, nowhere did the pretrial chamber
For these
suggest
reasons,
that it was
having
precluded
rejected the defense's
from
argument
assessing the
under this
information
ground of appeal,
about Mr.
the
Duterte's
first
health
ground of appeal
within the
is
context
rejected.
of its assessment under Article 60.2 of the statute. Rather, it noted
Second
the
ground of
reports
appeal.
placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show
Proposed
that the
conditions
pretrial
of
chamber's
release and
approach
state
was unreasonable. For these reasons, having rejected the defense's
The appeals
argument
chamber
under this ground of appeal, the first ground of appeal is rejected.
is of the view that the pretorial chamber did not appeal
Second ground of appeal. I will now turn to the second
to
ground of
implement
appeal.
the necessary
Under this ground, the defense challenges
the
the pretrial
chamber
chamber's
did not
assessment
consider
of the
release with
proposed
conditions
conditions of
as required,
release
but
and
found
state
that in
warranties.
the circumstances before
The
it,
defense argues that the
risks
pretrial
it had
chamber erred in
identified
law in failing to address the proposed conditions of release
could
and
not
state
be mitigated
warranties.
by the proposed condition.
The appeals chamber is of the view that the pretorial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which acted Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58 1B of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties.
It is also
In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58 1B of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable.
That all the three risks under Article 58 1B of the statute were established. As such,
Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58 1B of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice,
regarding
the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected.
Were not sufficiently
Third ground of appeal.
set out in the case at hand.
Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release,
That it is not
the appeals chamber considers
apparent
that the
from
pretrial chamber did
chamber's
not refuse to address the
assessment,
question of
that
interim
it was
release on
unreasonable.
humanitarian grounds.
The
Rather,
pretrial chamber
it gave the reasons for which, in its view,
found
the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand.
imposed upon release.
Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable.
Relevant information before it
The pretrial chamber found the existence of risks under Article
In light of the
58(1)b of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release.
erred in its assessment.
The pretrial
For
chamber
these reasons, the third
then proceeded to analyze whether humanitarian
Ground of
grounds,
appeal
as argued
is
by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It
appeal
follows
presented
that
by
the defense has failed to
in the appeal
demonstrate
brief,
that the pretrial chamber's
appeals chamber's
assessment was
unanimously
unreasonable.
confirms
Accordingly, the
impugned
appeals chamber finds that the defense has failed to show that the pretrial chamber
This
erred
brings
in its assessment. For these reasons,
us to
the
end
third
of the
ground of
summary
appeal is rejected.
the appeal
Finally,
judgment.
the appeals chamber notes that the pretrial chamber
The
reached its
judgment will
conclusions
be
in
notified to the
relation to the risks enumerated in Article 58(1)b of the statute on the basis of a comprehensive assessment of the information before
The hearing
it. In the
is
present case,
adjourned.
having rejected the three grounds of appeal
All rise.
presented by the defense
will,
in the appeal brief, the appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will.
Pursuant Article 58(1)b of the statute, a chamber assesses whether the arrest of a person appears necessary. 1, to prevent a person from not appearing at trial. 2, to prevent a person from obstructing or endangering the investigation or the court proceedings. Or 3, where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The Pretorial Chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The Pretorial Chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence.
So, ano pa rin po tayo, patuloy po tayo magdasal, patuloy pa rin po tayong umasa na meron pa rin sapat na katapatan ang mga huwes sa appellate chambers na malinaw po naman po sa basa ko sa Estado na dapat talagang ma-dismiss na ang kaso dahil laban kay Tatay Tigong dahil binigyan tayo ng karapatan bilang isang dating miyembro ng ICC na bumitiw sa pagiging miyembro at dahil tayo may ganyang karapatan, hindi man ibig sabihin na forever na dapat makatulungan ng mga bansa sa ICC. Binigyan po sa tingin ko ng Estado ng isang taon lamang ang korte mismo para humingi ng pakikipagtulungan sa mga miyembro kung gusto nilang lipisan ng isang bagay na nasa lugar nila. Pero dito po, wala silang nasimulan. Kasi nga po, ang pagsisimula ng engagement sa hukuman ay yung preliminary investigation, hindi preliminary examination na ginagawa lamang. So, mga kaibigan, malapit na araw po ito, inaasahan, pero sana umaasa po tayo ng katanungan, pero hindi na po napagbigyan ang hiling ni Tatay Tigong na sa dito po ha, una, sa tingin ko po mali yung mga basihan ng hukuman na sinasabi ko pwede sa tumakas at kung pwede pakialaman ng konstitusyon dahil yung mga ebidensya na pinaniwalaan nila ay mga pangalawa, naniniwala ko na yung estado ng ebidensya kung malakas o hindi pinayagan ng isang host country para masigurado ng pagkakas. Hindi lang po ako makakomento kasi hindi ko alam kung may mga yan. Pero ang sabi ng hukuman ay hindi nga daw kapatro para maiwasan. Kasi dahil karamdaman yung pagiging limot-limot na ni Tatay Tigong, hindi daw yan sapat on basis of humanitarian ground na mapagbigyan ang panambigyan kalayaan. Malungkot po, pero narito po ang ating mga kababayan. Tatanong po ako ng mga opinion galing sa ilang ating mga kababayan. Kayo po na naiiyak po kayo, ano po ang masasabi niyo sa desisyon na yan?
Nalulungkot po ako sa desisyon. Hindi nila binigyan ng chance si tatay ng movie. Sa niya.
Hindi nga po nakakalungkot po, no? Tayo talagang akala natin at least yung sense of humanity ay iiral, no? At mabibigyan ng panandaliang kalayaan. Dahil hindi naman natin sinasabi na wala na, no? Willing naman na talagang palabasin lang sa kulungan ng 19 anyos na natutumba na, no? Tumatama ang ulo sa sakit.
Pag-uan na lang ti, pag-over na lang ti, kay sarado ka.
It's not fair. It's not fair. It is nothing. All I want is...
Maawa kayo sa matanda. Isipin ninyo ang ama ninyo at kanuno ninyo. Ayun ni Tatay Digong. Hindi na siya makakitinig sa sarili niyang paa. Mga kasalanan, naghihintay ang mga
Here in Holland, this country, the international human rights is in this country. Our former president is old. And he gets nothing.
Hindi ka maging presidente with atin. Pinalibing niya ang ama mo. Binangon niya ang pangalan ng mga Marcos. Yan ang ipinagpalit mo. Yan ang pinagbayad mo. You are paying bad return with Duterte family. Please, release him. Ang power nasa kamay mo. BBM. Hindi masama kung ipalaya-layasin mo si Tatay Digong. Isip sa bayad, sa paglibing ng ama mo. Kung may utak ka, may puso ka. Mabuhay si Tatay Digong. Please release. Let him go.
Maraming salamat po. Well, parating din po ngayon ang apo ni Tatay Digong, si Omar. Asa po natin si Omar para sa kanyang reaksyon.
Nandito ka.
Na bawat sabihin niya, mangyayari. Susutang sinabi niya na, tirahin natin yun. Ganon, naniniwala sila.
Oo, totoo.
Ganon. Kaya, but the defense failed to establish that this is not support na
This is the
kung
way
ano
we
sabihin
love.
niya.
Oo,
We are only
oo.
supporting him kasi he's doing good in our country. It's
Yes,
not because
yes.
he's telling us what to do o ano ginagawa natin
Oo.
sa kung anong gusto niyang pagawa sa atin. Yun ang
Oo.
nangyaring paniniwala ng chamber na masyadong malakas ang influence sa pati siya kung siya ipapakawalan, pwede siya magdikta sa mga followers niya.
Ano ba
The
yan?
one thing to prove is nanalo siya ng mayor sa Davao.
Oo, oo.
And that shows only na napakalakas ng influence niya.
Sir, direct to the point, sir. Kung si BBM Bongbong Marcos ang magsabi, i-alis si Tatay Digong. Maalis na yan.
Kasi sa akin nawala eh.
Tingnan mo, sa akin to.
I am 30 years old here in Netherlands.
Yeah.
80 years old, nobody sit in jail. Let him free. No, you are not agree with me because trillion ang niwakaw ni BBM.
Yan pong dapat iwasan natin. The chamber thinks na
We are here in the same...
magugulo tayo, mag-create tayo ng problems.
Nobody.
No, hindi pa
The big heavy-handed President Marcos must be. One word
Hoy,
is
hindi
enough.
tayo kaaway dito.
Marcos is enough. Duterte must be released because he's the president. He's the big power. In Netherlands, 80 years old, must be out in jail. Let him free. You cannot stand here.
Sana naman longer than that. Limited time na lang meron. So, sana pinagbigyan na lang time para sa pamilya niya. Wala naman i-consider ang health niya, wala rin. Hindi ko alam ano pang i-consider nila. Ang age niya, yun lang ba?
The grandson.
Binigyan yung apila na maging makatao o humanitarian crime.
Congressman Omar.
Kung first time mo mapasok sentence, kalaki-laki nakasabi humanitarian court. Hindi ko alam saan banda doon sa appeals chamber nila na may humanitarian na reason para i-deny siya interim release.
Congressman Omar, what is your reaction on the changes?
Well, of course, it's a bit gloomy, especially with the weather right now. It's befitting. As you know, my grandfather is 80 years old. I don't see the the risk, they're telling the defense team that they failed to see grounds on his interim release appeal. Half the time while we are talking, he doesn't even know why he's in there, in detention. The other half, he doesn't know that he's here. He's in the Netherlands. So I don't see what they don't see. He's 80 years old. He's got maybe 5, 7 years. I think it's better he should spend those time with his family.
Congressman, ano pong plano ng family ngayon na ganito po rin?
Well,
They are not listening anymore.
you can't just sit down lying doing nothing. Still continue the fight. And if all our supporters are still with us, this is not the end. This is still just a part of it. This is still the continuation of a fight to bring him home.
Well, anong oras po ang dalaw niyo sa kanya ngayon?
It's around 1:30.
Siguro naman po, sinabihan na siya ng mga abogado.
Alam nyo, usually kung papasok kami, it's all smiles. Hindi, ayaw namin ipa-feel sa kanya na sad ang atmosphere. Pero, sige lang, konting time pa man. Medyo naano lang ako sa decision kasi grabe takong grounds.
Si Manong ay gibidyo pa dyan kung ang kainap ko. Ibayad naman ko din sila. Mayawa, mga gani.
Malapit ka lang dito, eh. 40? Layo naman.
Si Manong man yung gibidyo man tangan.
Tapos merong mag-sponsor na country, the country itself will be blamed kung mawawala si Tatay Dick.
Ano, bakit nila i-ho-ho? Bakit hindi release i-ho-ho?
Please tell me your name. Hi, I'm Aldwin Villarta. Hi, I'm Aldwin Villarta. Yeah. Sorry? Aldwin.
Aldwin?
Yes. Villarta.
Villarta.
Yeah.
Okay, and you represent the supporters of
Yes.
Mr. Duterte. So tell me, what is your reaction on this decision of the court?
Yes, of course, my reaction of this is very sad. It's very unfair because as we Filipinos, our culture look at it differently. But of course, the court looks at it as well on a different side. They see as if our support towards Duterte is a negative thing. However, they should not be looking at that. They should be looking at the support of the Filipino people, that we want him, not because he has power towards us or he has power to control us, but it is us willingly and that we are willing to actually support him because he has done so much. It's us giving back the love that he actually gave us. So that's how I see it. It's unfair, and that should not be the case, and that should not be the decision of this court.
It doesn't say anything to you that he is accused of the crimes against humanity. How do you reflect on that? You know, with all these people who died during his regime.
Yes, but the thing is, it doesn't have to be like that. I have the facts with me, actually. I have the facts with me. Where in fact, it is here, through the police report, even the CNN has reported about it. I will read on it because I
Tell me, okay, you have your facts. Just tell me, what is your reaction on?
It's not true. All the cases that are sent or all the cases that are being told about him is not true because we have the data and the data does not lie. We have them, and if anyone who actually needs all those datas, we can give them. Data is a fact and facts is facts.
Okay. Thank you very much.
Thank you so much.
Thank you. Can you please just
Nakapila na sila dyan.
This is from
1888. Is rejected. This is the fourth appeal. The third rejected. And then the last one is that, oh, maybe. The human sa
34. Thank you so much. Yes.
Dumaan yung mga bangag. Hello? Saya kasi nagsisapot.
Problema eh, bigit na yung time ng tatay.
Kaya nga eh.
Pag-asa na lang natin na yung mga nagiging time niya, magsaya siya.
Tayo yung kalaban natin ng
Yung mga opportunity natin taga-Europe, pasiyahin siya. Kung makalabas siya dito, sa magsabansakan. Yung mga kaligayahan mabibigay natin sa kanya. Siguro pang-apat na punto, tumaas ang tourism nila dito. Ayaw din na rin.
beautiful hair. Nagkanta biya ka mo? Nag-cheer mo, nag-ubi mo. Sagit na ko. Sagit na ko. Sabi ito video. Yung video na ko para i-share. Anak mo guys? Ingat pa siya galing. Grabe dito biliwat. Ito po ang ginagawa. Yan po ang ginagawa. Medyo. Kasi maganda.
Head spear, either. Since 2017, I don't know if you heard about it. No problem. Kami yun, sabi niya. All over Europe. Dito pala sa atin.
Dax, ano siya po sir? Kahit mo nagkakape.
Ang prayer namin, kita namin mga taga-Europe sa tatay ko.
Okay, thank you.
Nakagawa pa naman sa ninyo. Nakagawa pa naman kasi ng taga-Switzerland kung saan lumin siya. Sabi namin yung mga yan sa
Yeah, but can you please Can you edit that in file as soon as possible? I did know the other thing. It's already there. Okay? Thank you. Cheers. Bye-bye.
Pursuant Article 58(1)(b of the statute, a chamber assesses whether the arrest of a person appears necessary. 1. To prevent a person from not appearing at trial. 2. To prevent a person from obstructing or endangering the investigation or the court proceedings. Or 3. Where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The Pretorial Chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The Pretorial Chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence. Regarding the first ground of appeal and the question of whether the Pretorial Chamber erred in law by relying on hypothetical and non-specific risks to find that continued detention is warranted, the Appeals Chamber recalls that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the Appeals Chamber observes that a determination shall be made concerning the possibility and not the inevitability that one of the events listed in Article 58(1)(b of the statute will occur, and that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The Appeals Chamber notes that regard to the Pretorial Chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)(b, subparagraph 2 of the statute, the Appeals Chamber notes that the Pretorial Chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the Appeals Chamber finds that it was not unreasonable for the Pretorial Chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the appeals chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the pretrial chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the appeals chamber recalls that there does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the appeals chamber considers that it is possible to discern how the pretrial chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the appeals chamber observes that this is only one of the factors that the pretrial chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings. For these reasons, the appeals chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. In relation to the pretrial chamber's reliance on the notion of a network of supporters, the appeals chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The appeals chamber has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 50. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues